Good evening. I see it's 6 o'clock, so let us start our Celebrate Sunshine webinar. I want to welcome you all, whether you're watching through the Zoom link, the Facebook live streaming page, or viewing it later on LWVKC YouTube channel. We appreciate your interest in educating yourself on the importance of government transparency in our democracy. My name is Donna Hoke. I am a past president and a 48-year member of the League of Women Voters. Currently, I volunteer as the chair of the League of Women Voters Kansas City, Jackson, Clay, and Platte Counties Observer Corps team. We are proud to host this webinar on the Missouri Sunshine Law as part of the March 2022 Sunshine Week. Our speaker, Ms. Casey Lawrence, is Director of Sunshine Law Compliance and Records Management for the Missouri Attorney General's Office. She will present a slideshow. There will be a break for questions in the middle and again at the end of the program. Please enter your questions in the Q&A section of the Zoom so League member Nancy Shalver can organize and present them. I would now like to introduce our speaker. In 2017, Ms. Casey Lawrence became the Director of Sunshine Law Compliance and Record Management for the Missouri Attorney General's Office after serving as a Sunshine Law Coordinator. She previously worked for the Missouri Secretary of State's Office as State Records Analyst. During her tenure as an analyst, Ms. Lawrence received Intergovernment Preparedness for Essential Records training in 2012. Ms. Lawrence has also served as a legislative assistant in the Missouri House of Representatives from 2007 to 2009. She graduated from the University of Central Missouri in 2007 with a bachelor's degree in history and political science, and from the University of Missouri in 2016 with a master's degree in public affairs. Please welcome Ms. Casey Lawrence.
Thank you so much, Donna. That was very, very kind of you. Thank you so much to the League of Women Voters for this invitation tonight. I truly appreciate it. I am going to go ahead and pull up the slide deck that Donna referenced earlier. I will have a slide for just about everything that we're going to talk about tonight. And the slides will also have some citations of law included in the bottom right-hand corner. Before this evening, most likely linked to your invitation, there should be a link to our Missouri Sunshine Law booklet. That booklet has all of the information that I'm talking about tonight. And when I reference a citation of law, I also include a page number. So if you do want to flip through that booklet and find the exact page with the full text of the citation available, please feel free to do that. And of course, if you have any questions, we will have those 2 question breaks. So we'll save everything for then. I'm going to go ahead and share my screen, and I will rely on my wonderful advisors here to let me know once everything is set up and everyone can see the slide deck. Are we all good, Donna?
I think we were going to use standard view, so we're thumbnailed across the top.
It is fine. It is fine. It's coming across just fine, Donna.
Okay.
Perfect. Perfect. Okay. So this is a presentation tonight on the Missouri Sunshine Law, and I've drafted this for those of us who are interacting with the government. So if you want to make an open records request of your local public governmental body, or you want to attend a meeting of the public governmental body, these are some tips and tricks for how to make that a little more seamless. So we're going to talk about the Missouri Sunshine Law, but I do want to clarify something very quickly. I am not an attorney. I handle education and outreach. I work with the Sunshine Law complaints that our office receives, but I can't give legal advice. Even if I had the entire governmental affairs team with me and all of our attorneys, we wouldn't be able to give legal advice to entities that aren't client agencies. So we don't want anyone to assume that this is legal advice. If you ever do need legal advice, you will need to go to your private attorney, or if you're a public governmental body, to your agency's attorney. I also want to clarify that today's date is March 14th, 2022. So of course, if there are any changes to statutes at the end of this year's legislative session that go into effect later on this year, some of the information in this presentation could change. So again, this is the information for how the statute is written today on March 14th, 2022. Okay, so let's start with public governmental bodies. The Missouri Sunshine Law is only applicable to public governmental bodies. Now, like all good chapters, the Missouri Sunshine Law starts off with definitions. And so the definition for a public governmental body can be found in section 610.010, subsection 4, and that's on pages 30 through 31 of that Sunshine Law booklet. Once you've read through it, it's a little lengthy, but what it basically covers are the types of entities that have to follow all of the rules set out in the Missouri Sunshine Law. So first, any legislative, administrative, or governmental entity, if it has been created by the Constitution or statutes of this state, or by order or ordinance of any political subdivision or district. Also, the Missouri Sunshine Law is only applicable to judicial entities when they are operating in an administrative capacity. The Sunshine Law does not actually cover your court records. If you want to know when the last circuit clerk was hired, if you want to know how much your courthouse spent on snow removal, those are the types of administrative functions that the Sunshine Law can help with. We can help you get records related to those topics. But when we're talking about the actual court cases, that's when you have to go through court operating rules to obtain those records. So the Missouri Sunshine Law is also applicable to a subcommittee. Now this is kind of a common tripping hazard, but it is any committee appointed by or at the direction of any of the other entities that are defined as public governmental bodies, and is authorized to report to any of the above named entities. So again, you'll notice that this is 610.010 Part 4, but it's subsection E as in elephant. So there's a lot of above named entities on this one. When it's given the purpose of recommending directly to the public governmental bodies, governing board, or chief administrative officer, policy or policy revisions or expenditures of public funds. Sometimes these these subcommittees aren't a permanent committee. Subcommittees can be temporary, and that's fine. It might be simply a committee to find and hire a new public administrator for the city. It could simply be a committee that is looking at the development of a new park and perhaps the purchase of new land. So again, these may not be permanent standing committees, but it is something you need to consider when you're talking about what types of entities have to follow all of the rules for the Missouri Sunshine Law. And then I also want to point out the quasi-public governmental body definition. I always like to point this out, especially when I'm working with volunteer organizations like the League, because I find that the volunteers that we work with and we talk to are often volunteering for more than one organization. My volunteers that I usually work with and talk to, they're volunteering for numerous different groups, and some of those might end up being a quasi-public governmental body. It would have to be a body that is organized under chapters 352, 353, or 355 of the Missouri Revised Statutes, or an unincorporated association which either, and this is where it gets a bit wordy, so I do apologize for all the text that's up on the screen, A, has a primary purpose to enter into contracts with public governmental bodies, or B, performs a public function regarding tax credits, tax abatement, public debt, tax exempt debt, rights of eminent domain, or contracting agreements on structures whose annualized payments commit public tax revenues. And then this is the important one, or receives an appropriation of money from a public governmental body. So if you are ever working with a nonprofit organization that meets some of these requirements, you might want to make sure you get your research done to make sure that you are or aren't a quasi-public governmental body and get a clear definition for that group. It is a question that we do get fairly often, but we can't make that kind of decision for you. Again, that would be under the realm of giving legal advice, and we can't do that for those individual private entities. But if you do ever find yourself working for one, you might want to consider looking into this particular definition to ensure that you are following all of the appropriate rules. So, to kind of paraphrase some of the common types of public governmental bodies, and you'll see me use PGB quite a bit. It's a little acronym we like to use, and PGB just means public governmental body. Those are state agencies, counties, cities, law enforcement agencies, special taxing districts, and public utilities, not private utilities. Private utilities are going to fall under the Public Service Commission, but some of the public utilities will be following the Missouri Sunshine Law. But on the other side of that, there are some entities that are not public governmental bodies, and we do receive a lot of questions about these. Homeowners and condo owners associations are not public governmental bodies. They won't have to, follow a Sunshine Law request. They have other rules and regulations regarding their records and meetings, but they're not something that our office can take enforcement on under the Missouri Sunshine Law. Private companies are not considered public governmental bodies. Private nonprofits that don't meet that quasi-public governmental body definition, and houses of worship are not public governmental bodies. But those are some of the types of entities that I have previously received questions about. So I did want to make sure that we kind of touch on those common ones that don't qualify as a public governmental body. So those are the public governmental bodies. They are entities that are required to follow the rules set out in the Missouri Sunshine Law. And so now we'll talk about how to get records from some of those public governmental bodies. So submitting an open records request. Open records requests should be submitted to the public governmental body's custodian of records. So you, as the requester, want to make sure you find out who that custodian is. Now, there are some steps that can make that easier. Public governmental bodies are required to appoint a custodian of records, and the identity and location of that custodian must be available upon request. So if you reach out to the public governmental body and ask them to tell you who that custodian is, they need to be able to provide that to you. So you will know who to send your open records request to once you've gotten it drafted. So once you know who the custodian of records is, you can go ahead and submit your request in a couple different formats. Sometimes a public governmental body is going to have an official request form. This can be really helpful. They might have a form at their front desk or a form online, and you can just go through and fill in all of the fields and submit your request. This does sometimes help speed up the process because it is generally an automated system for those larger public governmental bodies, and they can get to your request pretty quickly. But that is not the only way a body can take your open records request. You can also just simply write in a letter or send in an email and direct it to the body's custodian of records and indicate that you're making an open records request. You can also make a verbal request. We have had people make requests over the phone or in person. I will go ahead and say that it can be more efficient to submit your request in writing. If you make a request over the phone and the phone call isn't recorded, or you make it in person and that's not recorded, it's going to be a little difficult to go back and parse out, you know, what exactly did you ask for? Did you give a date range? Did you give search terms? You know, situations and details like that, that we may not be able to confirm later on if we do have to look into a complaint. We have found that it is very efficient to go ahead and submit your request in writing. It protects you as the requester because you know exactly what you asked for and you've got a copy retained for yourself. But then the body has it and can reference it again. They're not sitting there asking themselves, oh gosh, did Casey Lawrence request all of these records for just 2022, or did she want 2021 included in her request? Writing it down does give you that type of audit trail, but it is not required. Also, a public governmental body cannot require that you use their specific form to make an open records request. They can ask you to use it. You know, Mrs. Lawrence, would you like to use our online open records request form? That's great. But they can't deny fulfilling your request because you didn't use their specific form. When you are making an open records request, you do need to include some contact information so the body can contact you about your records. I do understand that some individuals would prefer to make an anonymous open records request. And for records that are open to the general public, you can. But you do still have to give the body a way to reach back out to you to, you know, if anything, let you know when your records are prepared, or to let you know how much the fee will be, or to let you know if they need clarification on your request. So contact information is important. I also want to point out that if you are ever making a records request for law enforcement records, there are some records of a law enforcement agency that are only available to certain parties, especially for records that are still under investigation. Only certain people can get a hold of those. For those instances, you may have to provide identification. You may have to indicate that you're the parent of someone involved in the event, things like that. So there can be some further rules on those types of law enforcement records. But of course, if you have any questions or concerns specifically about law enforcement records, you know, do feel free to give us a call. We'll be happy to walk you through that section. I will put up my contact information on the last slide, so you guys can give me a call or send me an email too. Once you've identified yourself, when you've sent in your open records request, you also need to describe the records you are requesting. If you happen to know that the record has a specific title, invoices or annual budget report, something like that, go ahead and give that title if you happen to know what it is. If you don't know the name of the record, try to provide a brief description of the record. For a lot of us, we don't really get involved with our local public governmental bodies until something may have gone wrong. So you've got water coming into your backyard, or you feel that an intersection is unsafe. So you may not have been interacting with certain groups in your local public government, but if you don't know exactly what type of records they have, you can still describe the documents. And they should be able to at least find you a few things to meet your description. It can also be very helpful to provide a date range. Sometimes we're asking for records that a body may have, 5 to 7 years worth of that record. Do you really want 5 years worth of that information, or are you just looking for the last 6 months? Providing that date range can really help narrow down what you're looking for. There are times when you are requesting records and either the record or a portion of the record may be closed. When you are making your request, you can go ahead and ask the public governmental body to provide you with the specific citation of law that allows them to close any of the records you've requested. So this is like a preemptive request. So I write a request to my local city and I say, could I please have a copy of A, B, and C? If any of these records are closed, please provide me with the citation of law that allows you to close them, because they are required to give that. Section 610.023, Part 4, which is on page 41 of the booklet, does indicate that if a requester asks for that citation of law in writing, the body has to respond back in writing within 3 days with that specific citation of law. So they do have to be able to tell you why those records are closed and point you in the direction of the appropriate statute for why those records are closed. I always like to tell people that you can't give the mom excuse when you're closing records. Because I said so, only works for mothers. It does not work for closing public records. So, whenever you're requesting records, you can also discuss format with a public governmental body. When we talk about record format, we are basically discussing records that are paper or electronic. You can go ahead and tell the public governmental body if you have a preference, and if the records are requested in a certain format, the body shall provide access to the records in the requested format if such format is available. Now, I always like to include one caveat, and this is especially important for those of you who are, working for a public governmental body. We all have constituents who may not have access to a computer or high-speed internet or any way to view electronic records. Because that is just a truth that we have to work with in the state of Missouri, there may be constituents who can only review records in paper form. Even if the record is stored electronically with the body, it's not going to be a format that's accessible to the public or that member of the public. So I do encourage public governmental bodies to find a way to work with that requester to ensure that they have access to the record as well. Okay, so this is a little tiny, but I did want to provide it. It is a copy of our sample open records request form. This is available online at ago.mo.gov. Under our Sunshine Law section on the page, we have some helpful forms that both members of the public and employees and elected officials for public governmental bodies can use. And this one is a records request form. It kind of walks you through some of the topics that I just discussed about describing the records, providing a date range, and then talking about what kind of information and how you'd like to receive it. This does go on to talk about fees as well. And I do have a section on fees coming up in just a few more slides, so we can dive into that a little more thoroughly then. But if you would like to, you can always address fees up front with the public governmental body, as opposed to leaving it for a conversation later on down the road. So up until now, we have been discussing things that you as a constituent can do to make your open records request, but you only have control of it really until it gets into the body's hands. So once the body has received your open records request, they are going to respond to you. And so what I'm going to go through are a few slides discussing the types of responses that you may reasonably receive from a public governmental body. The first thing to look at is the response time. A public governmental body has to act on an open records request as soon as possible, but no later than 3 days after the request was received by the custodian of records. So if you send an email tonight, it's Monday night, and you send an email to the city's custodian of records, and she comes in tomorrow morning on a Tuesday, and she gets your open records request. So Tuesday would be the day she received it. Even if you sent it on, Monday evening at 6 o'clock in the evening, it's likely after the time where she's left the office, and she's going to check her email the next day. So she gets it on Tuesday, and then she has 3 days after the day she's received it to respond to the open records request. So that would give her Wednesday, Thursday, and Friday to respond to the open records request. I have received complaints before from individuals who sent me the complaint even before the 3-day time limit was up. So we were able to work with the body to ensure a timely response went out, which is good. We want to make sure all the public governmental bodies are sending out timely responses to open records requests. But I do like to point that out. Just because email is so universal, and we can communicate after office hours, and we can send things to people, when it's convenient for us at home, that doesn't always mean that the body received it at that point in time. This is also not including weekends and holidays. So for example, we'll have an interesting state holiday coming up. We have Truman Day on May 8th. That's actually a Sunday this year, and so it's observed on May 9th. If you send an open records request that weekend, please note that the state custodians of records will likely not receive it until May 10th, and that'll be the day they receive it, and then add 3 more days to that for when they will be expected, deadline for responding. Those holidays and weekends are something we do need to take into consideration as well when you are expecting a response from the custodian. Also, if you've only provided a mailing address, please note that there could be a little more lag time in getting a response back from the public governmental body. So here's a quick list of all the different types of possible responses you can get from the public governmental body, and we'll go into each of these in a little more detail. The first is easy peasy. Records that you requested are provided. So you asked for a copy of last month's meeting minutes. 2 days later, they email you with a copy of last month's meeting minutes. That's great. It's simple. It's nice to see. But that is just one type of possible response. You may also be notified that no records exist. Dear Casey Lawrence, thank you for your request for meeting minutes for February of 2022. Due to the 7 snow days that our school district had, the school board did not meet in February of 2022, and we do not have any meeting minutes. That's a possible response. They may also advise the requester that they need more time to fulfill the request, and we'll talk about that further. It may also inform you that the records you requested are closed, and it could also alert you that there may be fees involved in obtaining your records. So there are lots of types of responses that you can receive from the public governmental body that are allowed, but we are going to dive into these a little bit. So first is the delay in receiving the records. So you've made an open records request, it's been 3 days, and now they tell you that they're going to need more time. That is okay to an extent. They need to give you the good cause for the delay and the expected date when the request will be fulfilled. Good cause can be a couple of different things. For example, if you have a city that is storing records in an off-site storage facility, they may have to request those records back. I do know that happens for larger entities, and especially state agencies, and we may have to wait for those boxes of records to be delivered to us. There can also be other good causes, things like, well, you've asked for budget information, and unfortunately, our budget officer is on vacation this week. We hope that she will be able to fulfill your request by this date. That's a good cause. You can't make your budget officer come back from vacation for an open records request, but you can ensure that they fulfill it as soon as they get back. What if there are closed records? Well, as we mentioned earlier, if you get a response and they talk about closed records, you can ask them for the citation of law indicating why the records are closed. The body will need to be able to provide a specific citation of law that allows for the closure. Now, those records closures are not only in Chapter 610. There are other statutes that allow for records to be closed. There are records, about juvenile offenders that will have to be closed, things about, social services that might have been received that can also be closed. The Safe at Home program through the Missouri Secretary of State's office allows for some information to be closed, but all those programs have a specific citation of law that they were built from and can be provided to you upon request. What if there aren't any records responsive to your request? It could just be a situation like the one I described earlier where a school board just kept getting snowed out of their meetings in February and didn't end up meeting for that month. It happens, but there's a case that a public governmental body may rely on and may cite to you. It is Jones v. Jackson County Circuit Court, and this is a Western District opinion from 2005. And in that, the court held that the Sunshine Law does not require a government body to create a new record upon request, but only to provide access to existing records held or maintained by the public governmental body. So if they don't have meeting minutes from February, they don't have to create any new document stating that they don't have meeting minutes from February. They simply respond to your request and let you know. Another way that the body may not have records is if they have been destroyed. There are records retention and disposition schedules created for all of the local and state public governmental bodies. For the local entities, these are created by the Secretary of State's Division of Local Records, and these are all available online at sos.mo.gov. They list out the different types of public governmental bodies that there are, and then once you click on that selection, you can read through their schedule, and it indicates how long a record has to be kept before it can be destroyed. So if you're asking for 10 years worth of information, but the body only keeps 5 years worth of that because of their retention schedules, they're only going to be able to provide you with 5 years worth of that information. All right, fees for open records requests. A public governmental body is allowed to charge fees for fulfilling open records requests. This is easily one of my most common questions every week. And I am pretty sure just about every week somebody does tell me that they don't believe that the fees are appropriate because they already pay taxes and taxes should pay for these open records requests. At which point I just have to direct them to the legislature because the legislature wrote the statute, and the statute allows for the fees that can be charged at the lowest salary amount for search, research, and duplication time, and that they can charge 10 cents a page for paper that is legal size or smaller. So when I talk about the lowest salary for search, research, and duplication time, I do want to give an example. So our chief counsel here, he's a very bright man. He could definitely use the copy machine, and he could go through and make 500 copies. But we can't charge his salary for making those copies when anyone else in the staff could have also used the copy machine and made the copies. At that point, you charge the lowest salary rate for the person who could have done the duplication. And also, the 10 cents a page is pretty self-explanatory, but I did once have a public governmental body that was trying to charge 20 cents a page, but they were being eco-friendly and printing on both sides. So I always appreciate, trying to save yourself some resources, but it does say 10 cents for a page of paper that is legal size or smaller. So when we talk further about duplication costs, not everything is going to be on a piece of paper. There can be situations where your records are on a DVD or an external drive. You can charge for that exact item. So if a DVD for you is 75 cents, then you can charge 75 cents for that DVD. You can also charge the exact cost of paper that is larger than legal size. And this follows along with the actual rate of compensation for items like maps, blueprints, and plats. These are the types of records that do require specially trained personnel to provide. It's not just something I can pull up on my computer and click print and go and pull it from the printer. These are items that will take a little more effort. Now, there are some entities within government that do have their own rates for providing records. The recorder's office, your local county recorder's office, does have their own rates listed into statute. So if you are ever making an open records request of a recorder and you say to yourself, that seems a little high for the Sunshine Law, please note that they have their own special fees for fulfilling those certain types of open records requests. Okay, I also want to discuss the fact that fees can be due prior to the fulfillment of the request. So the public governmental body can request payment of copying fees in advance. We always tell the public governmental body that it is very helpful to alert the requester before they go ahead and finish making all the copies of what the expected cost to obtain the records will be. I have seen, terrible situations where, you as the requester expect a small request and you think, oh, it'll be $20, I'll get the records I need. And then all of a sudden the body calls you and it's, $475 and the records are ready right now and you should come and pick them up. That's not a good situation for either party to be in, because you as the requester are allowed to back away from any request. If you don't feel that you want to pay that much for records, you don't have to. You won't be getting the records, but you can, of course, back away. There's nothing holding you to making that payment. And for the public governmental body, you may also want to consider that if you've just done, all of this work and spent $475, you might want to have checked with the requester first to ensure that you're going to, recoup that cost. Requesters, what you can do is you can indicate early on, usually in your original request, the amount of fees you are willing to pay. So please let me know if the fees necessary to fulfill the request will be over $50. That way the body knows. If it's under 50, just go ahead and fulfill it. She's going to come and pay for it. But if it's over 50, give her a call. Let her know. Say, hey, Casey, this is going to actually be about $89. Are you still interested in getting all of these records? This can also allow the requester and the body to really talk about, what records are going to be delivered in this request. And are these records that the requester even wants, or are some of these superfluous items? A requester can ask that fees be waived for fulfilling an open records request. Some entities, want to make sure that this isn't going to be information that's then used to make a profit somewhere else. So you might have to provide some information about how you're going to use the records if you ask for a waiver. But I also want to point out that the body does not have to waive the fees. even if you've requested a waiver and even if you aren't going to be using the information to make a profit, the body does not have to waive the fees. Those are still allowed to be charged. Okay. So we have reached the end of the discussion of submitting open records requests. Do we have any questions about this topic?
We have one question in the chat.
Great.
What are the consequences when an entity does not respond after a request sent over many weeks? And this person got a response when a letter to the editor was published. But what are the consequences?
Well, the Missouri Sunshine Law doesn't give a lot of consequences for just like saying, oh, well, you didn't respond, so here's an automatic action. You do have to file with the court. So if you as an individual say, okay, I don't like what they did, I'm going to go file with the court about this particular matter, you can do that. We also have a process for handling sunshine law complaints where we reach out to the public governmental body, let them know, here's this request from Casey Lawrence. She indicates that she made the request back in early February. It's now mid-March and she hasn't gotten a response. What do you say to that? So sometimes we can help get a response. We do have a complaint process slide that I'll go through at the very end, but we can help obtain records. We can help educate public governmental bodies. Sometimes we find that there may have been a mistake, or there may have been a misunderstanding, or we don't know what happened, but we can help educate and mediate and hopefully get you a response to your open records request.
Very good. There's another question. What if the custodian of record is out, either sick or on vacation or something like that?
That does happen. So if the custodian of records is out, they won't have received your open records request. So if it's, like a sick day, I call in or well, I'm not our custodian of records, but if I called in, hey, my kids are sick, I have to stay home with them today, I wouldn't be able to receive any open records requests, but I would receive them the next day. That does tend to kind of, push back that timeline. When it comes to things like vacations, planned leave, where you're going to be gone for an extended period of time, we encourage a public governmental body to take note of that and prepare, have a response ready. Dear Casey Lawrence, thank you for your request. Our custodian of records is out of the office until what would be March 18th, and will return to work on the 21st. We expect all open records requests to have responses 3 days after her return. That way you can kind of, preempt those types of questions. It really becomes difficult for a constituent when they send in a request. They don't know that the custodian's out on leave. They don't know that the custodian will be gone for an extended period of time. But if you can keep up the communication as the public governmental body and respond, hey, we're not the custodian, but we're letting you know, they will be in touch with you. That's very helpful to the constituent. I mean, no one is going to begrudge anyone their, medical leave or vacation time. It's something, we all generally take. But if you can keep that communication open and up to date, that's what really helps constituents. Then they know when to expect a response. It's that radio silence. That you've put in a request and you haven't received anything, where the constituent starts to ask themselves, well, did I send it? Did it not go through? Are they just ignoring me? And sometimes that can lead to some animosity between the constituent and the government, and that's not what the Sunshine Law was intended to do. It's intended to, you know, keep everybody on the same page so we can all see what's happening all the time.
Okay. Other than the media, who requests records? And is the 3-day response typical? I mean, this questioner says they've heard of reporters state that they've waited for months to get responses.
Well, there can be a delay in obtaining the records. So again, you get that 3-day letter, but it may say things like, we need this much time to fulfill your open records request. And I think it depends on the type of information requested and how much information is requested. You know, asking for last month's meeting minutes is a much different request than asking for the last 15 years worth of meeting minutes. That request is going to take a little more time to go through and process. But as far as who requests records, I don't know that I could qualify that into a single group. I've had concerned citizens. I've had, you know, unfortunately, sometimes people who have been involved in a traffic accident, they have to request a record from a local law enforcement agency about their accident, you know, just to get their insurance processed. You know, just about anybody who interacts with the public governmental body on the local or state level at any time can make an open records request. We even had, when I first started and I was a Sunshine Law coordinator, we had a question from a city because they had received an open records request from a young lady who was not yet 18. They wanted to know if they had to fulfill the request. And the Sunshine Law doesn't have an age requirement. So even if you are, you know, just old enough to put pen to paper and you want to make an open records request of a public governmental body and you can pay the hourly rate and the 10 cents a page, you can get the records. So yeah, the press makes requests, the public makes requests, and everyone in between. And sometimes even private companies will make requests of public governmental bodies. And then they'll usually end up using the information to monetize, but everybody makes open records requests.
Okay, a few more questions have come in. Can you comment on why it took so long for Clay County to release its records?
Oh, I can't comment on individual situations.
I understand. What was the recent Supreme Court decision on excessive fees on sunshine requests?
I think you might be referring to the case of Gross v. Parson.
I don't have any specifics. Can you explain what that was?
Yeah, it was a Supreme Court case. It was decided this past summer, and it did discuss questions about fees, when fees can be charged and when they can't. The full text of the Supreme Court decision is available online. I think you could even make a request of the court for it, but I do believe it is just free of charge online if you want to go through and read any of that.
Okay, great. One more. Could you address the changes that proposed House Bill 2049 would make to the Sunshine Law in Missouri?
No, tonight's presentation is about the statute as it is written today, and that's what we're going to be sticking to today.
All right. I think, looking here, I think that is all of the open questions at this point.
All right, do we want to take a quick 12-minute break? That'll get us right to 7 o'clock for our public meetings section.
Sounds good.
Okay, sounds good.
This is Donna. Casey, we may want to shorten that to maybe 5 minutes, give people a chance to get a drink of water or something?
Sure thing, Donna, we'll make it 5 minutes.
Thank you.
Mm-hmm.
Hi, Donna. This is Terry, the tech person. I'm just thinking we probably ought to have a little bit of something in here if people jump online, that we are taking a 5-minute break and we will resume at 6:54.
Yes, let's be sure people know that. And I may take this opportunity, as you hear from Ms. Lawrence, she is not prepared to talk about current legislation, but we do want people to be aware that there are things going on in the General Assembly that could provide changes. The Senate Bill 930 did pass out of the Senate committee on Thursday, the 10th. And you might want to note that down to have a look at that bill to see the changes that are proposed. But again, it's just come out of the committee, has not passed the Senate.
And Donna, there are 3 bills that the league has identified that are in the House but haven't really moved. Do you want to just give a brief overview of those House bill numbers and the summary for each?
Let us see if I can go to that on my computer. The thing about the 3 bills I've been able to look up is that they really haven't even been assigned to committee. So with everything that is going on, we do think they may founder and not move forward, but you still need to look at them. House Bill 1500. I'm going to have to get my sheet up, guys, before I can talk about them.
Okay, but I think that we do want to let people know that members of the League of Women Voters get a weekly legislative update of bills that are moving in the legislature to allow you to voice your opinion as a constituent on bills that are moving through the legislature. So that is one of the wonderful perks of being a league member is I, as a person who's moved from out of state, I'm still learning about Missouri, and it can help me understand the discussions that are going on and when I'm able to make my voice heard with my legislator. Hi, Casey. It looks like we're going to get started again at this time. Thank you.
All right. Okay. So the second half of the Missouri Sunshine Law deals with public meetings. So at first we discussed how to get public records from your public governmental bodies. And this is about attending their meetings. So let's go through again the definition section. When you have a public meeting, it is defined in section 610.010. This is on part 5 on page 32 of our booklet. And this is a meeting of a public governmental body where a quorum is present at which public business is discussed, decided, or public policy is formulated. So these can happen a number of different ways. 2 years ago, I think most of us were used to in-person meetings. That was how we saw most public business be conducted. You would have, your board or your council sitting at one end of the room, facing the audience at the other end of the room. But meetings can take place other ways. The statute does contemplate electronic communication, conference calls, or online chats, or internet message boards. The definition also continues on to include the term public vote. So if you are having a public vote of all or a majority of the members of a public governmental body by electronic communication or any other means conducted in lieu of holding a public meeting with the members of the public governmental body gathered at one location in order to conduct public business. So that public vote could be considered a public meeting. So that's something to look for. We do want to see those public votes. I know everyone always says that, you don't want to see the sausage being made in government, but I would say different. I would say that with all of the people I know that want to attend public meetings, they do want to see the public business take place. But we also want to talk about what is not a meeting. The term public meeting shall not include an informal gathering of members of a public governmental body for ministerial or social purposes when there is no intent to avoid the purposes of this chapter. And that's very important, the intent. We want to make sure that you're not just, having a little meeting of 2 or 3 and then another meeting of 2 or 3 and then, making decisions in those small groups and saying, oh, well, it wasn't a meeting, we didn't have a quorum. Because at that point, it would feel a bit like you are trying to avoid having your public view the meeting. But the informal gathering happens a lot, actually. In fact, this summer, we had numerous bicentennial events. Cities across the state were having their own bicentennial events. There were the statewide bicentennial events. And at most of these, you would see a quorum, if not the entire board, gathered. So there'd be a group of the public officials. They'd all be elected. They'd be there at the dedication or a ribbon cutting or at a parade. But those were not events where they were going to discuss public business and formulate public policy. Those were, kind of social and ministerial. Dedicating a plaque is more ministerial. The business beforehand, the meetings where they discussed what was to go on it, who was to get the contract, how much they paid for it, things like that, would happen at a public meeting. But the actual dedication of an object like that wouldn't necessarily be considered that type of event. Now we've seen those types of things, bleed into each other. I've seen a, Christmas party held in the early afternoon and then a quick board meeting right after to just pay the bills for December, and then everybody goes home. But if you're going to have an event like that, make sure that you're making it clear to the public. Again, when the public wants to attend a meeting, they want to know what's going on. They want to see the governing happen. So if they ever, drive by City Hall and see that everybody's there, the assumption is that if all of my elected officials are there, that perhaps some governing is happening. And so we might want to be privy to that. So we do want to make sure that all of our elected officials are aware of what is a meeting and what is not a meeting, because as we move through the rest of this section talking about requirements for meetings, all of these requirements have to be met for any of the public meetings. Now, there are only 2 types of meetings that are defined in statute, and those are open and closed. I know that when I read through meeting minutes, I will see lots of different terms used to describe public meetings. I will see things like executive session and working session, or budgeting meeting. Those are all very helpful terms, and they do help specify to not only the elected officials, the staff, the public, what may be happening at this meeting. But if you're going to have an open or a closed meeting, it might be more helpful to specify that. I am just going to speak up a little bit from experience. My father was in the Air Force, so we moved around a little bit. And sometimes we would move places and people would, of course, call things, by different names. And if in one place they had executive meetings that were just for votes, but another place they had executive meetings that were closed, we may not be aware of that differentiation. That has to be spelled out. So I always encourage public governmental bodies, when you draft a meeting notice, draft it for someone who just moved to town. Draft it for someone who hasn't been living there, for the last 50 years and knows exactly what's occurred at every previous meeting. Go ahead and give that type of information that will alert people as to what is going to occur at the meeting, and tell them if it's open or closed. When you have a meeting, you have to post a public meeting notice. This notice must be posted 24 hours in advance of all public meetings, both open and closed, and this is exclusive of weekends and holidays. So if you are going to have a meeting on the Tuesday after Memorial Day, your meeting notice must be posted no later than the Friday before, because the Saturday, Sunday, and Monday will not count for that 24 hours. So if it's a 6 p.m. meeting on the Tuesday after Memorial Day, you can't post that meeting notice any later than 6 p.m. on Friday before. When you post the meeting notice, there are some required fields. There is the time, date, and place of the meeting. There needs to be a tentative agenda, and this has to be reasonably calculated to inform the public of the matters to be considered. And if the meeting will be conducted by telephone or electronic means. So if you are not just meeting at City Hall, where there will be chairs set up for everyone to come in and sit down, but you're going to have, a Zoom meeting or a Facebook Live meeting, you need to be able to tell the public this. And you need to be able to tell the public how they can attend that type of online meeting. This is also the time when a meeting notice needs to be posted online. So if you have, been informed that there will be an online meeting for your local City Hall, you should be able to find an online meeting notice for that same meeting. If you attend a meeting, you are allowed to record that meeting. The body shall allow members of the public to record public open meetings. This is both audio and video. You can make a recording. The body can establish guidelines regarding the matter in which recordings are conducted. So if you are going to ask that all of the video cameras be set up along, the back wall, or that everyone, set up on, the east side so that they're not, reflecting off of the windows or something like that, that's fine. You can, set up those types of guidelines and rules. If you are going to do that, it's very helpful to make sure people know about those recording rules. Try to have a copy available. A lot of city clerks tend to just have one in their meeting packet, which can be very helpful. But just make that information available to anyone who might want to make a recording. Now, the third bullet point is for the closed meetings, and mostly for the board members, because they're really some of the only people who attend those closed meetings. But closed meetings cannot be recorded without permission of the public governmental body. So if you're going to record a closed meeting, you have to get permission from that public governmental body. If you don't, this can be up to a Class C misdemeanor. I never used to really teach about this until there was one situation where it happened. It only has to happen once. And it kind of really split a city board, kind of down the middle. There was a lot of animosity. You know, people were very upset about this particular recording. And it just, you know, I'm not even sure that the recording itself got any good information. I think it was just your general closed meeting information. But I think it ended up making a lot of people upset. So I do want to point out that you can record those, but you do need to get that permission first. So now that we're talking about closed meetings, I do want to talk about some of the authorizations for that. When you close a meeting, there are 24 separate authorizations listed within section 610.021 that talk about how you can close a meeting. They talk about different topics, and if your meeting is going to relate to the topics in those sections, you can close the meeting. You can also use section 610.021.14 to close your meeting for a purpose that is listed in another statute outside of chapter 610. So if you need to discuss something with another public entity and you need to use some of their citations of law to close that particular meeting, you can. You just need to make sure you're referencing the appropriate section of law. When we talk about those 24 separate reasons, they are, you know, they can be different and distinct, but they can be used together. You need to make sure as the public governmental body that you are, you know, only closing to the extent necessary, that you are only closing the meeting to talk about the topic that you've set out on your agenda. So here we are, we're going to have a city hall meeting and we're going to close under section 610.021 sub 2 to discuss a purchase for real estate. That's fine. You're allowed to do that, but just make sure you don't get off topic. Because if you're talking about the purchase of real estate, but then you also want to talk about, well, hey, once we purchase this real estate, are we also going to need to create a bid for who the vendor will be? And okay, well, let's write some bid language. You can also go into closed meeting for the discussion of, you know, drafting a bid and things like that. But you never told the public about that. You never told the public that's what you were going into closed session for. So you want to make sure you're sticking to your topics. And on the other side of that, we also don't like to see the whole kitchen sink thrown at the agenda. No one likes to see all 24 reasons for exceptions to openness listed on a meeting notice. That's not helpful either, because then the public doesn't know what you're talking about, because it listed everything you could possibly go into closed session for. So do be careful and conscientious with those citations of law. So the process for closing a meeting is set out in section 610.022, and these are sections 1 and 2 that I've cited here on the slide. The first requires an affirmative public vote of the majority of a quorum of the public governmental body, and this is with a reference to that specific section of 610.021. It's not just standing alone. It'll be 610.021 and then parentheses, whichever number or numbers you selected. And then part 2 requires a meeting notice with reference to a specific section of 610. So these are the rules for how to properly close a meeting. We have seen where, you know, a lot of bodies just go ahead and use both. They provide the public meeting notice, they hold the public vote, and this is really just a really efficient process to ensure you've properly closed your meeting. Neither one of these steps is terribly time consuming. Neither one of the steps takes a lot of staff time or funding or anything like that. You're adding a line to the notice you're posting to your door, and you're taking a vote at the public meeting. So these are definitely in the category of what we call cheap and cheerful solutions for a public governmental body to go ahead and implement both steps. I also want to talk about location. For those of us who are attending a public meeting, if we are not one of the elected officials and there comes time to have a closed meeting, we will not be able to stay for the closed meeting portion of the public meeting. But the public governmental body holding a closed meeting shall close only an existing portion of the meeting facility necessary to house the members of the public governmental body in closed session, allowing members of the public to remain to attend any subsequent open session held by the public governmental body following the closed session. So this is really important. Sometimes the board is so much smaller than the group that came to attend the meeting that sometimes the board removes themselves to a smaller area to have their closed session. Other times it's the only place to have a meeting, so the public moves out to a lobby or something like that. But do make sure that if you are attending a closed meeting or you're attending any meeting, that you're aware of these requirements when it comes to closed session. If you are a member of a public governmental body, you can also object to going into closed session. Members have the ability to file that objection and vote against going into closed session. If a member objects, their objection is required to be recorded in the body's meeting minutes. So this is something to check for once those meeting minutes have been drafted. So once they've been drafted and they're getting ready to be approved, if you objected or someone on your council or your board objected, you will want to check those meeting minutes to make sure it's listed there. You also want to make note of the fact that even though someone has objected to going into closed session, it doesn't mean that they are barred from attending that closed session. They can fully participate in any meeting record or vote on that issue. So if I object to going into closed session because I don't think it's an appropriate reason for going into closed session, that is something that I need to make sure gets entered into the minutes, and I can still attend that closed session meeting. I also want to talk about a sunshine law policy. Sunshine law policies are required for every public governmental body. So every city, county, special taxing district, you are required to have a policy. And it is open to public inspection. So if you would like to see the sunshine law policy of any of your local public governmental bodies, you can put in a request for this information. It is something you are allowed to review. We have a sample sunshine law policy. It's on our website. It's also on page 15 of our booklet. It is a whereas resolution. So for any public governmental body that is, considering updating or needs a revision, you can look at that option as well. And that is, of course, free to the public for anyone who wants a copy. Okay. I also want to talk about the AGO complaint process. If you have a complaint about a public governmental body and how they are, following the sunshine law, you can send us a complaint form. Our first step in any of these complaints is to gather information. So we get information from the complainant, and then we gather information from the public governmental body as well. We do find it helpful to educate the complainant, educate the public governmental body, make sure everyone's on the same page. If we need to, we will do a little mediating work, work with both sides to navigate the records request or the meeting issue and try to see what sort of help we can provide. In severe circumstances, our office does litigate. We have filed petitions against public governmental bodies concerning, sunshine law violations. So that is something we do, but it is not our first reaction. Again, we do find that education helps get everyone on the same footing, and it ensures that hopefully this doesn't happen again. I do offer trainings like this all year long. I will also be able to travel in person. We kind of held back on those while the weather was a little iffy earlier this year. But now if we can have, beautiful sunshiny days like today, I will be happy to get back out on the road and travel to any of your locations to give a presentation on the Missouri Sunshine Law. We also have presentations specifically on law enforcement records, if anyone is interested in that, or if you happen to know anyone at your local law enforcement agency that would like a training on law enforcement records. So, any questions on attending a public meeting and what you might expect to see there?
Casey, we have one question that's come in so far. Are public records and recordings of public meetings in Missouri in the public domain?
So they are the records of the public governmental body. So when I say public, I know a lot of times people will confuse that as just automatically meaning open, but when I say public, it's of the public body. They have certain things they have to retain for a certain amount of time, and they can, place them online if they'd like to, but there isn't a specific requirement for them to do that.
Okay. Looking for other questions here. I guess a follow-up to that, copyright status.
Okay, so copyright can affect a few records that make it into the hands of a public governmental body. If a record does need to be closed, that is a decision that the public governmental body's attorney will likely need to make for them. So if you've received a bid and it talks about, a copyrighted or a trademark process, there might, be a case made for closing some of that information because it is given, protection under federal law. So if that is a concern, the public governmental body can, of course, take it up with their attorney. But again, they're not allowed to close any information without being able to provide you with a citation of law indicating why it was closed.
Okay. Can you talk about the difference between the Federal Freedom of Information Act and a Missouri Sunshine Request?
Only briefly. The Federal Act, of course, is for all of our federal government entities. I will say that generally, when a local public governmental body receives something that's called a FOIA request, they still act on it. We don't insist that people use, a magic term in order to get their request fulfilled. If people send in something and it says FOIA on it, we understand that to mean that they're making an open records request. I think the biggest difference between the Missouri Sunshine Law and FOIA is, of course, the time requirement. You can wait a lot longer to receive records from the federal government than you can from the local public governmental bodies. I will say that as far as FOIA is concerned, I think there are some good federal references, but I do believe SMU has some online information regarding FOIA if you do have some further questions. But since I don't really deal with it very often, I mostly just have to send people, to the federal government because we can't help with fulfilling federal records requests. But if it was just a misused term to get local records, then sure, I can help you get some local records.
Okay. I want to go back to the earlier discussion of recordings of meetings. So there is no requirement to provide a recording of a meeting. Is that correct?
So if a body has recorded their meeting and have they received a request for it?
I think the question is just, are bodies required to record their meetings?
Oh, no, they are not required to make a video or audio recording of their meeting. They are required to keep meeting minutes. That is in section 610.020, part 7. And those meeting minutes, do have to have the time, the date, the place, members present, members absent, and a record of all votes taken.
Okay, great. And what is the average time for records retention? 5 years, 10
Oh,
years?
there really isn't an average time. There is a general records retention schedule that the Secretary of State's office puts together for local public governmental bodies, and that'll cover some of the types of documents that just about every public governmental body creates, and then that's used by multiple entities across the state. But it really depends. I mean, there are some records that do have to be kept permanently, and there are others that are maybe just a few months. It really depends on the content of the document. But yeah, you can always read through those records retention schedules. The Division of Local Records is an excellent resource, and of course they put all of that out online, so you don't even have to make a request. You can just go and view it anytime you'd like.
That's great. How long after a meeting should the minutes be available?
That's not something addressed by the Sunshine Law. There isn't an exact time frame for when those draft minutes have to be prepared.
Okay, well, I'm looking through and not seeing any other questions at this time.
Nancy, I have some.
Please go ahead, Donna.
A couple. One, if we have a entity we're observing that does not put the date of their meeting or their agenda online, they're not in compliance with the Sunshine Law. Am I correct on that?
So if they're having an online meeting, they should be able to post an online notice. But if this is an in-person meeting, then the online notice isn't required.
So how do they post? Because they do not have a every second Tuesday scheduled. It depends on the commissioner's own personal schedule. Do they just have to put up a notice in their office that they're having a board meeting every 3 months?
So 610.020 part 1 talks about those requirements for meeting notices. And I'm going to find you the exact language because it still talks about bulletin boards. Posting the notice on a bulletin board or other prominent place which is easily accessible to the public and clearly designated for that purpose at the principal office of the body holding the meeting, or if no such office exists, at the building in which the meeting is held. And that's at the top of page 34 of our Missouri Sunshine Law booklet. And that's considered the reasonable notice for an in-person meeting, is that that notice is posted there 24 hours in advance, exclusive of weekends and holidays, for that public meeting. That can be a little difficult if there isn't a standard, like you said, second Tuesdays or every other Thursday, something like that.
Okay, thank you. The other question I have is, is it considered an open record for a candidate to provide their contact information, including an email address? And is there a section we can quote in educating some smaller towns?
So the Sunshine Law gives you some exceptions to openness in 610.021, but 610.011 talks about kind of that overall definition. And it states that all records are considered open unless there is a specific citation of law that allows for the information to be closed. So if a body wants to close the information, they have to be able to provide you with a citation of law that indicates why it's closed. Again, we can't just say, because I said so. there does have to be a citation of law indicating why the record would be closed.
Because some of this is personal feeling that I don't, as the clerk, I don't like to give out people's personal email address. And so that is probably not a good enough reason.
Again, unless there's a citation of law, the record can't be closed.
Then my third question is, when you have a posted agenda that routinely gives 3 reasons that they might, a city council might go into executive session, like personnel issues, real estate issues, and I forget what the other one is, but then they
Usually
vote to
legal.
go into executive session, but they never say which of those 3 they're using.
That could be an issue, but again, without knowing, the exact details of a situation and what was posted and what was discussed, I can't say. That's why we always have to receive a complaint and then look into the matter, because we just can't say, yes, that's a violation, no, it's not. We do have to look into it. But if there is a situation that gives you concern, please let us know. We do have an online Sunshine Law complaint form. You can also send it to me at sunshinecomplaints@ago.mo.gov. That comes directly to me, and we'd be happy to take it up for you.
I think they were discussing a TIF agreement, which was probably legal for them to be in session, but I
Just some
question.
confusion about the
Yes, I
appropriate
was
citation.
confused.
Okay. Yeah, and it's something too that you can always bring up to the local public governmental body. 610-022, those sections 1 and 2 talk about the process for properly closing a meeting. You can always, provide that to the elected officials. I do like to train, and I do know that there are a couple other individuals in the state of Missouri who do go around and give sunshine law training as well, but I know we can't reach everybody all the time, and I will say that it's sometimes a little difficult to get everywhere across the state, but we do try to make it to Kansas City fairly often, so maybe we can help.
Thank you. I do know for the first time, I believe, in recent history, that the State League had to file an open records request to get the addresses for the people appointed to the redistricting commission, the bipartisan redistrict commission, because they just couldn't find it out on any public site. And they did get it. They did comply and provide it, but you had to really search or file the concern. I've taken that time. Is there any other questions? I'll turn it back to Nancy.
I still don't see any other questions from our audience.
Well, thank you all for, giving me some of your time this evening. I know that's sometimes our most precious commodity. So if there are no further questions or concerns tonight, I'll go ahead and sign off. But of course, this is my contact information, so if you want to follow up and ask us any questions, I'll be happy to get back with you. And have a safe evening, everyone.
Yes, I do want to say the League of Women Voters of Kansas City, Jackson, Clay, and Platte. Sure, we want to thank our speaker, Ms. Casey Lawrence, for this educational presentation. I'm sure if you're like me, you've learned a lot. And also remember that this meeting was recorded and can be shared with others via the LWVKC.org website, and you click on the YouTube channel icon. We thank you all for participating in the Sunshine Law presentation. Please be aware that the 2022 Missouri Legislature is considering several bills that may change the Missouri Sunshine Law, and we need to be following them. Missouri's Sunshine Law went into effect in 1973 and was one of the leaders about open government. So we can be proud of that if we just don't change it away, because We know open government is good government. Thank you all and good night.
Hi, everyone. Thank you.